Good afternoon, everyone. I want to welcome you to the latest installment of our Know Your Rights workshop series. My name is Jannelle White. I am the director of the Temp Worker Union Alliance Project, housed in Warehouse Workers for Justice. So as usual, we're going to get started with going around with introductions and having everyone say a little bit about the organizations that they represent. So I will toss it to Mark first.
Hi, my name is Mark Birhanu. I'm a staff attorney with Raise the Floor Alliance. We are a coalition of worker centers in Chicago and the surrounding counties, and we provide shared legal and policy support.
Thank you so much, Mark, for joining us. As always, we appreciate your partnership with us and bringing these Know Your Rights workshops to our viewers, followers, and subscribers. Speaking of which, those of you that are tuning in, please be sure to like, comment, and share, even if you're catching the replay. Also, I'd like to invite you at this time to leave any questions or comments that you might have for Attorney Mark in the comment section, and we'll be sure to get those to him as well. So once again, my name is Jannelle White, and you are now tuning in to the Know Your Rights workshop series. We're going to be focusing on temp workers and general workplace health and safety and your rights to organize in the workplace. Mark has prepared a presentation for us. So I'm going to tell you a little bit about Warehouse Workers for Justice and TWUAP. So TWUAP, the Temp Worker Union Alliance Project, is housed in Warehouse Workers for Justice. Warehouse Workers for Justice is a worker center fighting for good living wage jobs in Illinois' warehouse and transportation industry. The Temp Worker Union Alliance Project, TWUAP, exists to build the bridge between unions and temp workers with the goal of building worker power with wall-to-wall union density. And last but not least, I'm going to toss it now to Tyler Cunning, who is joining us for the first time from Temp Worker Justice. Thank you for being with us here today, Tyler.
Thank you so much for that, Jannelle. Good afternoon, everyone. My name is Tyler Cunning. He, his, him pronouns, and I am the digital organizer for Temp Worker Justice. Temp Worker Justice is a national nonprofit organization for temp workers. We like to support temp workers and other organizations that we partner and allied up with that also support temp workers through various campaigns and other means as well. And in conjunction with that, I would also like to announce to you all that Temp Worker Justice will be working in collaboration with Temp Workers Union Alliance Project on an upcoming Know Your Rights series. It will be a 4-part series where we cover things from how to report issues that you're having at your workplace to different government agencies, your general rights in regards to are you able to organize, are you able to join a union, and how to go through the proper chain of commands and procedures in regards to filing those complaints and who to go to file those initial complaints and things like that. So make sure you all tune into that. We'll be dropping more information about that later on both of our social medias, and feel free to reach out to any of us, both Jannelle and myself, if you have any questions in regards to that, or if you're also interested in serving on a panel for that event as well. Thank you.
Yes, thank you so much, Tyler, for joining us today and for that wonderful introduction. I am so excited about our upcoming series and looking forward to, as you said, posting more information about that as well. So before I turn it over to Mark so that he can get into his presentation, I actually want to take a minute to share with our viewers all of our websites, because how are you going to get in contact with us if we don't share that? So give me a second and I'm going to pull up our websites. All right, there we go. So first, if you're interested in reaching out to any of our staff organizers at Warehouse Workers for Justice, that website is www.4j.org. And if you are interested in speaking to myself or any of our other organizers that work with TWUAP, Temp Worker Union Alliance Project, that website is TWUAP.org. Next, if you are interested in speaking to anyone at Temp Worker Justice or taking their surveys, they are doing some groundbreaking work with surveys targeting temp workers across the country. So their website is tempworkerjustice.org. And last but not least, if you are interested in speaking with anyone at Raise the Floor Alliance, specifically their legal team, which Mark Birhanu is here representing, that website is raisetheflooralliance.org. So now, without further ado, I'm going to go ahead and turn it over to Mark Birhanu. Again, we invite you to please like, comment, and share. And if you have any questions for Attorney Mark, please leave them in the comments and we'll get those over to him. And hopefully he'll be able to answer them while we're live.
Thank you, Jannelle, and thank you for sharing our contact info. All right, I'm going to get into it. So I have a presentation today about generally about workplace rights with some specific information about workplace rights dealing with COVID. Can I get a thumbs up to make sure this presentation is visible?
Yeah,
all right. Always struggling with this. Thank you, Jannelle. Okay, so the first right I want to talk about is the right to organize. So, this is not a right specific to COVID-19, but we'll talk a little bit about how it might come into play in the context of the COVID pandemic. So generally, Section 7 of a federal law called the National Labor Relations Act protects the rights of employees to engage in, and I'll give you the legal term, concerted activity for the purposes of mutual aid and protection. So within that is included two or more workers taking an action, and I'll provide more examples of what an action might look like. For example, two or more workers presenting a petition to their bosses demanding better treatment. Also falling under the protection of the law are situations where one worker calls upon other workers to act. This is called a call to action. So think of, in the break room, a worker stands up and says, hey, we need to take action to push our employer to take better COVID precautions or to pay us more. That is what would be called a call to action. So usually when one worker is acting, it's not protected by the law. The law really deals with the collective, the group of workers coming together. The exception being when one worker is asking others to stand up for their rights together. So in order for an action to be protected under this law, under the National Labor Relations Act, it must involve workers discussing work matters. So high-level political issues, unless they're directly bearing on the conditions of the workplace, might not invoke protections. That's why you always want to include some language in your demands around specific workplace issues. So the law applies to employees of private employers. There are, in most states, including here in Illinois, separate state laws protecting the organizing rights of public employees. So talking about this law, the NLRA, it applies to most employees of private employers with an exception of supervisors and management. Just because someone is designated a supervisor doesn't mean they are one under the NLRA. Think of situations where a worker is able to make independent hiring and firing decisions. If you're designated a supervisor, but you really don't have any control over the workplace, you don't get to hire employees. If you want to discipline an employee, you have to go through all these other channels. You might be considered an employee for the protections of this law, in which case you could band together with your coworkers without being retaliated against, making demands upon your boss. So the law, like most laws passed in the New Deal era around the Great Depression, does not apply to domestic workers and does not apply to independent contractors. As far as independent contractors are concerned, this is another situation where your title isn't totally dispositive. So just because you're called an independent contractor doesn't mean you are one. So the key thing that courts will look at here, that the National Labor Relations Board would look at here, is how much control do you have over your day-to-day? Would you be able to work another job? Or are you scheduled every day? Do you own the equipment, or is it provided by the boss? So, if you're an independent contractor and you have, or if you've been designated as an independent contractor and you have questions about whether you'd be covered, you're thinking about taking action, talk to a worker center. They'll put you in touch with an attorney or talk to an attorney directly.
Mark, if I could interject here quickly for a second. I'm so glad that you took some time to kind of flesh out what exactly qualifies a worker to be an independent contractor, because as you know, a lot of temp workers are often categorized as independent contractors, but from doing the work as organizers, we know that a lot of them are stuck in these situations that we've labeled permatemping, where they're going to the same site assignment, long term, sometimes even years, but for whatever reason, they haven't been afforded the opportunity to have permanent employment, or what is known in the industry as becoming a direct hire. So I think it's important to note that temp workers do have the right to organize. And, it's a huge misconception that they don't, and that they don't have, the right to participate in collective bargaining. So I just wanted to highlight that for any of our viewers who might be watching. And again, friendly reminder to like, comment, and share. And if you have any questions for Attorney Mark, please leave them in the comment section. Thank you, Mark.
Thank you, Jannelle, for that very helpful commentary. I just, by way of illustration, we've had cases in the past where a temp worker was assigned to a client company, tried to organize at the client company, and then was terminated by the, so he was sent home by the client company, and subsequently his assignments to the temp agency were canceled. So both the employer, and so the employer meaning the temp agency, and the client company got dinged. They got dinged by the National Labor Relations Board for having taken retaliatory action against this employer, or for having threatened retaliatory action against this employee. So in a temp situation, either the client company or the staffing agency itself can be held liable for violations of your organizing rights, depending on the circumstances. Okay, so how to actually file a charge with the National Labor Relations Board. So, I'm assuming most people in here are in Illinois, or are, close to Chicago, or somewhere around there. You're going to want to file at the local regional office, the Chicago regional office of the National Labor Relations Board. Depending on where you are, you might have a different National Labor Relations Board that is assigned to handling your charges, or a regional office, I should say. The charge must be filed within 6 months of the violation. So, that's a little shorter than we'd like, but it's important. If you've been retaliated against for organizing, meaning your hours have been cut, or you've been fired, or you've been given less favorable work, maybe your boss is making you lift heavier things, you got to file your charges within 6 months of that change in your employment conditions. Again, the charge can be filed against either party that violates your rights, whether that is a staffing agency itself or a client company.
And Mark, if I could ask another question here, I'll try to refrain from commenting.
No, please do. Please continue.
I know the answer, but I want people to hear it from you, because I think, because you're a staff attorney and who focuses in this particular area of the law, you lend a lot more credibility. So question, yeah, question, do workers need an attorney to file charges with the NLRB?
No, they do not. So they do not. I'd encourage workers, however, to work with some organization, whether that is a union or a worker center, just to make sure you're getting everything down that you need to get down. But no, absolutely not necessary. You can file the charge yourself. The process is designed to be orchestrated by workers themselves. Here in Chicago, the board moves pretty fast. So from the time you file your charge to the time you're getting a call from an investigator, it moves pretty fast. So you can expect a call. Honestly, I've gone within a month of filing a charge. The board is more likely to, what I've found in my experience is that all agencies are more receptive, are faster acting when there's organizing, like media attention. They're very curious when they see a news story. So-and-so has filed a charge at the National Labor Relations Board, and they're like, it can sometimes prompt them to be like, who's the investigator assigned to this charge? We need to make this priority, et cetera. So yeah, totally, file on your own. And I think, if you're waiting on an attorney, or you don't want your rights to lapse, right? You have 6 months there. So if you're finding like you're not able to get your charge filed, you're not able to find legal support, yeah, might as well go ahead. The investigations are usually pretty broad. So let's say you state in your charge, I was retaliated against by my boss on such and such date. They're usually pretty forgiving in terms of like, that sort of degree of detail. They would still look into all different kinds of retaliation that you might have faced, just because you didn't put it in the charge specifically. But it can be helpful kind of just to give them a idea of what to zero in on by being more specific. So the answer is no, but I would encourage folks to work at, with a community, with an organization to file charges.
Thank you, Mark. Because yeah, I know a lot of times it can be super intimidating for workers trying to navigate all of this and in the face of injustices in the workplace. So I just wanted to highlight that, while I'll echo, we do encourage workers to at least reach out to a worker center so that we can, hopefully make referrals to legal teams where they have staff attorneys like Mark that are dedicated, to these sorts of workplace injustices. But in the event that you can't get legal representation, you can file on your own. And if you have more questions about that, feel free to reach out to us. We're happy to answer them to the best of our capabilities, or again, make those referrals. Thank you, Mark.
Thank you, Jannelle. All right, so let me get to some, I promised this earlier, let me get to some specific examples of, what are the activities what are the sorts of organizing activities that are protected? So some examples: discussing work conditions, circulating petitions, discussing joining a union, taking a strike. Those would all be forms of concerted protected activity. So another example related to COVID-19, maybe you want your employer to bring back its mask mandate. You get back together with your employees, with your coworkers, do a petition, stage a protest outside. Those would be protected activities. You do not need to be working with a union in order for your rights to be protected here. But if you are wanting to talk to a union and you want to talk to your coworkers about joining a union, those conversations would be protected. So just a note on strikes and work stoppages. There are, and I'm simplifying a little bit here, there can be more protection afforded under the law when you are not just discussing economic things. So let's say you got together with your coworkers and you're striking to demand higher pay. Technically, your employer, you may have a right to permanently replace you, right? That's not technically firing. They can't fire. But if they fill the job with permanent replacements in the meantime, that's okay under the law, provided your protest is only over economic conditions. So if, this might be a situation where you want to bring in other demands, like COVID safety demands. You might, if the, and this is what's afforded the greatest protection under the law. If you're protesting about actions your employer has taken to stifle organizing, maybe they're surveilling your organizing, or they fired an like one of your lead workers who's organizing the workplace. Those are what are called unfair labor practices. And protests, strikes related to unfair labor practices cannot result under the law in permanent replacement of striking workers. Okay, so I want to get into OSHA a little bit here. So the Occupational Safety and Health Act. It's also, OSHA is also the abbreviation for the agency itself that is charged with administering rights under this law. So this is a law many people know about regarding requiring safe conditions in the workplace. One of the most powerful provisions of the law, especially related to COVID-19, is the anti-retaliation provision. So 11C of the Act protects workers from retaliation due to raising concerns about health and safety. So let's talk about how this differs from the National Labor Relations Act. So here, there's only 30 days to file with OSHA, but there's not the same restriction under the National Labor Relations Act of having to act with your coworkers. You can raise an issue yourself here that wouldn't be protected under the National Labor Relations Act, but is barred from being, subject to retaliation under OSHA. But you do have to move fast. You have 30 days to file a complaint with OSHA, which you can do on the website. Let's see. So there in Chicago are more powerful protections related to COVID-19 than elsewhere in the state. Now, the most relevant ordinance here in the city, and there's a couple, is the Chicago COVID Anti-Retaliation Ordinance, which prohibits employers from retaliating against employees for obeying an order issued by the mayor, the governor, the city of Chicago, the city's Department of Public Health, or your individual physician that has to do with COVID-19. So if you receive an order to quarantine due to COVID-19, or if there is if the Chicago Public Health Agency Chicago Department of Public Health has an order requiring anybody who contracts COVID to stay home to minimize transmission of COVID-19, they can't be fired. And there's pretty steep penalties here. You can't be fired just for quarantining in the city of Chicago. So workers have a couple remedies when that happens. One is they can file a complaint with the Office of Labor Standards, and I've got their number here. They can also file a lawsuit. And with a lawsuit, workers are entitled to 3 times what they would have earned had they not been retaliated against. So calculating from the time that they've been fired to present, multiply that by 3, the amount of wages that you would have earned. There's steep penalties under this law, provided that the employer is in Chicago. There is an employer cap here, so I believe the size is 4. The employer must have at least 4 employees. The worker, must perform work in the city of Chicago at least, I think, 2 hours within a 2-week period. But yes, this is a very strong, in my opinion, and underutilized ordinance in Chicago. Second, so we got a question. We have a viewer question.
Yeah, we do have a viewer question. So is a change in work assignment or being moved to a different department considered a sign of retaliation?
Absolutely, provided that it isn't a favorable change. So a change in hours to maybe a less favorable shift, where the employer hasn't made the same change to the schedules of other workers who haven't engaged in protected activity. But yeah, no, definitely, maybe they've moved you to a hotter, less comfortable part of the workplace. Yeah, that can also be a sign of retaliation. So you want to think of retaliation pretty broadly here.
I got a question. You spoke about the 2 hours of work being performed in the city. Would they count if the temp agency takes you out to the suburbs? Would you count the time that you ride in a van? Would that be considered 2 hours? And would that protect you with the Chicago ordinance?
So I'd say it depends if if you're required to come into the office ahead of time and taken out to the suburbs. I'd say this is a very, I suggested this earlier, this isn't an ordinance that has been really used a lot. So questions like that haven't been tested. I think there's an argument that yes, that sort of employer would be protected. But if you're not in Chicago doing any work within, I think it's 2 hours within a 2-week period. I think it's unlikely, frankly, but those workers should call the Office of Labor Standards. Maybe you're required to come in for specific orientations or trainings. We know that temp agencies do that sometimes. They require workers to come in for those sorts of things. So it's an open question. I think it's worth pursuing if someone has that issue. But yes, it is unresolved. All right. I'm going to get into earned sick leave, which is, again, a Chicago-specific ordinance that also applies in some Cook County suburbs. So Chicago and some Cook County towns have passed ordinances that give employees the right to earn sick pay. So that's an important caveat there, is that the sick pay is accrued. A worker accrues 1 hour of paid sick leave for every 40 hours they work, for a total of 40 hours of paid sick leave in a year. Sick pay cannot be taken until the worker has been working for the employer for 6 months. The employee can carry 20 of those hours of unused sick pay to the next year. Paid sick leave can be used either for a personal illness or for the illness of a close family member, or for court dates related to domestic violence. An employer is not permitted to require a doctor's note if you're sick for 3 days or less. So, you can text your employer, I'm sick, I need a day off. Provided that you've accrued paid sick leave, you can take the leave, and your employer can't require you to provide a doctor's note. Let's say day 4 hits, they can. So in Chicago and certain Cook County municipalities, which are listed at the bottom of this page here, there are also rights related to getting your vaccine. So there is what is called the COVID-19 vaccination rights for employees and employee obligations ordinance. Under this ordinance, an employer cannot require employees to get vaccinated outside of work hours. So let's say your boss says you need to get vaccinated to work here. They can't then say, hey, wait, but you need to get your vaccine outside of work, outside of work hours. If the employer requires you to be vaccinated and your appointment for the vaccine is during your shift, you must be compensated up to 4 hours of pay at your regular rate per dose. If your employer does not require you to be vaccinated, you can use your paid sick leave to go get vaccinated. So provided you've accrued paid sick leave, you've been working at the employer for at least 6 months, you can use your paid sick leave if you're in Chicago or in one of these Cook County suburbs to get vaccinated. Now, importantly, the earned sick leave law and the vaccination rights laws do not apply in every Cook County suburb. The ones that it does apply to are listed at the bottom of this page. I'll go through it real quickly because I understand it might be small. Barrington Hills, Berwyn, Cicero, Countryside, Deerfield, Dalton, Evanston, Glencoe, Glenview, Kenilworth, Lincolnwood, McCook, Northbrook, Oak Park, Oakbrook, Phoenix, Skokie, University Park, Western Springs, Wilmette, and Winnetka. There are some missing municipalities on that list where we know a lot of our workers are working. We're not seeing Brighton Park down there. We are seeing a few that a lot of our temp workers do find themselves in. For example, University Park, Cicero, but a lot are missing. If you're in Chicago, it does apply. However, both these laws do apply. All right, so reporting ordinance violations. So for all of these ordinances that I've talked about before, you can file a lawsuit, but you can also go to a respective city or county agency. So for violations of Chicago ordinances, so paid sick leave ordinance violations under Chicago law, vaccine law requirement, vaccine ordinance violations under Chicago, in the city of Chicago, you can call the Office of Labor Standards at 312-744-2211. If you don't have the number readily available and you're experiencing violation, you can also call 311. When you tell them what's happening to you, they'll connect you directly to the Office of Labor Standards. If you're in Cook County, if you're in one of those municipalities where the earned sick leave and COVID vaccination rights ordinances apply, you can call the Cook County Commission on Human Rights at 312-603-1100. You also have other options, which you've discussed. You can talk to a worker center about ways to address violations of those rights through organizing. You can also file a lawsuit in state court. If there are violations of federal law, let's say you've also been discriminated against, you may be able to tack on one of these state law claims to a federal claim in court. You're going to want to talk to an attorney about where to file if you're thinking about going to court. And I want to stress something because, as I was going through those slides, you saw how many places aren't covered. So many places in Illinois have no paid sick leave. So many places in even just Cook County don't have the paid sick leave protections or the vaccine protections. So you can do a lot through organizing that you can't do purely through the law. The law does have its role here. We talked about organizing rights at the federal level, those protections. So the law does have its role here in providing that background protection. But the National Labor Relations Act doesn't say you get to have higher pay. It doesn't say you get to request that your boss provide paid sick leave. It does say you can make those demands without being retaliated against. You can do a protest, get media attention. We've seen in this space so many changes that weren't required by the law that were accomplished through organizing. So the last thing we want is for workers to hear, I don't have a right to paid sick leave, so I'm not going to do anything about it. You've got a lot of eager people in this room willing to help you come up with organizing strategies. So
Absolutely. Thank you so much.
Hungry even.
Yes. Thank you so much for taking the time to talk about sick leave, because as you know firsthand from the referrals that we send your way, we've been encountering a lot of workers, an alarming rate of workers that feel and have some validity to their feelings of being retaliated against during this pandemic. If a person has to take off work to care for a loved one, or if they themselves have contracted COVID-19, they shouldn't have to worry about not having a job to come back to, or being penalized when they're following the safety protocols set in place, mandated either by the CDC or the city or whomever. Employers need to be respectful of that. And we're here to help. So again, to echo what Mark said, if anyone's watching this and you feel that you may have been retaliated against in regards to earned sick leave, and you'd like to know more information or figure out if you do have any course of action, feel free to reach out to TWUAP, WWJ. We'll be happy to connect you with Mark or someone on staff that can give you more detailed answers to your questions about this issue. This is why we're doing these workshops, so that we can get this information out to you guys and make sure that you're armed with knowledge in the workplace, and that you, no pun intended, know your rights. So
that's right.
And if you have any questions for Attorney Mark, again, I invite you to leave them in the comment section, and I'll turn it back over to you.
And just to say one thing, if you have any questions about wanting to help with organizing your workplace, feel free to reach out to WWJ or TWUAP. We can definitely help you and guide you through those steps.
Yeah, so Bobby's been popping in. He was a little under the weather when we first started, but folks, that is Bobby Frierson, a staff organizer at Warehouse Workers for Justice. He also works with TWUAP, Temp Worker Union Alliance Project. So, again, we have so many organizers on staff that are ready, willing, and able to listen to your concerns, answer your questions to the best of our knowledge and ability, and make referrals when need be to the legal team and the good folks over at Raise the Floor Alliance. So thank you guys, those of you who are watching. Again, we invite you to like, comment, and share, and leave any questions that you have for Attorney Mark in the comment section.
Thank you both. Okay, so kind of just a final topic here. I want to talk about workers' compensation. The law around workers' compensation has changed quite a bit here. So just providing some background before getting into the COVID specifics of it. So workers' compensation, the Illinois Workers' Compensation Act provides compensation to workers for injuries suffered on the job. Examples of injury types are injuries caused by repeated use of a body part at work, pre-existing conditions exacerbated by work. So, maybe you have, a pre-existing foot or ankle injury, and it gets worse because of your work conditions, and injuries caused by equipment at work. There's important procedures to follow with regard to workers' compensation. So first is that you should notify your employer as soon as possible, no later than 45 days after the accident of the accident itself. So notice can be oral or in writing. Seek medical care immediately. You should tell your doctor that you are considering filing for workers' comp, and speak to an attorney that specializes in workers' compensation. That would not be me, but both myself and TWUAP and WWJ do have very strong workers' compensation attorney referrals. So workers' compensation and COVID-19. So there is, for COVID that is contracted within a certain time period, a rebuttable presumption. I apologize, in a previous presentation, I did not share the expiration of the presumption. But what it means is that if you catch COVID-19 in the workplace, if you're an essential worker, the law assumes that you caught COVID-19 in the workplace, provided that you're an essential worker and that you contracted COVID between March 9, 2020 and June 30, 2021. So this past summer. It's important that you did follow the 45-day notice provisions. So, maybe you told your boss within that time period, I've gotten COVID, then you're out of work, you don't get paid, you don't have any sick pay. That period of temporary incapacity could be covered by workers' compensation. So it applies to many types of workers, including healthcare workers, first responders, many essential workers like construction workers, manufacturing workers, and grocery store workers, when they're required to interact either with the general public. So think of, grocery store worker who has to work with the general public, or for workers in those categories who must work with at least 15 employees. So if you're a manufacturing worker, chances are you've got to work with a lot of employees. 15 is on the lower side of that. If you are a manufacturing worker, you catch COVID-19, or you caught COVID-19 prior to June 30, 2021, you told your employer you're sick, they didn't pay you anything because, let's say the Family First Coronavirus Response Act, which used to provide paid sick leave, did not anymore, it had already expired. You may explore compensation through workers' compensation. So if you have questions about the rebuttable presumption and whether COVID-19 would be an illness covered by your workers' compensation insurance, call the Illinois Workers' Compensation Commission directly at 312-814-6500. We can also put you in touch with the workers' comp attorney. So just because you're a worker for whom the rebuttable presumption doesn't apply anymore, let's say you got it yesterday, well after June 30, 2021, you can still file a workers' compensation claim. It's just frankly a little harder because you don't have the automatic assumption that you caught it in the workplace. You can present evidence. For example, 7 of my coworkers also tested positive, or I was around somebody who got COVID the night before or a couple of nights before I started contracting symptoms. I only went between home and work, and then I got COVID, stuff like that. It is worth exploring with a workers' compensation attorney, even if you don't enjoy the rebuttable presumption, seeking workers' compensation for that period of temporary incapacity. So that's all I've got, but I want to stick around for a little bit to answer any questions about, either from folks on the call or viewers on Facebook or wherever they may be.
Sure. Well, thank you, Mark. As always, we're grateful to have you with us and appreciate you putting in the time and the effort to put together the slide presentation with all of that information. We do have another viewer question. So let me see if I have this right. The question is, how does employment work when you are required to take time off due to a lack of work? So I hope I'm getting this right. I think maybe this is asking about being laid off because there are no assignments for a temp worker or a contract employee, something along those lines. And George, the viewer who left that question, thank you. If that's unclear, if that's not it, feel free to comment again under Facebook, and I'll get that over to Attorney Mark.
So I would say that, so is it maybe the question about unemployment? If it is about unemployment, you can apply for unemployment for periods where there's no work, even though you're still on the rolls. When there's a furlough, or if your hours have been reduced substantially. So let's say, you were working 40 hours a week, then your hours get cut because there's no work to 20. You can apply for partial unemployment. So yeah, that's a really good question. It comes up in the context of temp workers a lot with fluctuating schedules, but the law explicitly protects partial unemployment or furloughs. You'll remember at the onset of COVID-19, a pretty significant amount of people who were applying for unemployment weren't fully unemployed. They were just, told that we're closing down the workplace for whatever, 3 weeks, a month. Tons of people applied for it and got unemployment during that period, even when they were still on the employer rolls. Very good question.
Yeah, thank you again, George, for that question. And Mark, thank you for taking it on. That is a recurring issue that we see with temp workers, which is why the temporary staffing industry in and of itself is giving folks what we call precarious employment. There's no guarantee to employment. And I mean, not to get into the weeds, if it's not clear by now, my feelings on the need for an overhaul and just more accountability and regulation in the temporary staffing industry in general should be clear, but there I actually said it. So I want to take a minute now to talk a little bit about some of our partnerships. So
can I say one thing on
yeah,
that still? So with temp employment, in the unemployment context, there is some regulation like requiring workers to call, like who are seeking unemployment, to call into the temp agency like regularly in order to inquire about work. I'm gonna look it up right now, whether it's daily or weekly. Employment. I'll say that's one of those it's one of those regulations that isn't heavily enforced, so it doesn't come up a ton. It's technically on the record that you should continue to be calling in to the staffing agency seeking assignments during the period of unemployment. Usually the temp agencies use other strategies in order to deny unemployment to certain workers. Like they might have told the worker, we're laying you off because there isn't work, but they might allege that they actually fired the worker because he was a no call, no show or something like that. Let me see if I can, it might, let me just say, to be on the safe side, you want to call in every day to ask about work during the period of unemployment. And it might seem silly, but it's just the safest thing you can do as a temp worker if you're trying to get unemployment.
Yeah, it's best to cover your bases because, it's a lot of these temporary staffing agencies, unfortunately, do not operate in general in the best interest of the workers. So It's good to, you know, do those things to protect yourself and cover all your bases. If anyone's watching, and also George, who started that line of questioning, again, thank you for that. If you have more questions while we're still on, feel free to leave them in the comment section. Thank you, Mark, for addressing that, because yeah, that, as I said before, that is a recurring concern with a lot of the temp workers that we encounter. So I'm looking, I don't see any more questions. So I did want to take a minute to talk about our partnerships with some of our healthcare providers, specifically the Cook County Department of Public Health. Both WWJ and TWUAP are grantees for their vaccine outreach program, and now operating under the CDC. So we wanted to share with you guys more information about where to go if you have not been vaccinated, or if you are in need of getting your booster shot. I'm going to share my screen quickly to show you where to go. All right, so you can visit cookcountypublichealth.org. Also, if you click on Find a Vaccine, it will take you to another dedicated site, myshotcookcounty.com, where you can see locations and hours, how to make appointments. There are always events happening in Cook County every weekend, every week. So if you have more questions about that, we encourage you to visit those websites through our partners with the Cook County Department of Public Health. And if you'd like more information directly from us about things that we're doing for COVID-19 mitigation, as far as PPE giveaways and vaccine awareness, also feel free to reach out to WWJ or TWUAP as well. Bobby, did you have anything that you wanted to add about that?
Yeah, and I would, excuse my voice, everyone. I also want to add that there are free rides to and from vaccine sites. You can request an Uber to and from. You can register at myshot.com. I'm sorry, myshot.gov.
Thank you, Bobby. Yeah, so please don't let not having a ride be a barrier for you getting your vaccine booster, and even flu shots are offered at those vaccine events and clinics as well. So without further ado, I don't think I have anything else. Mark, did you have anything that you wanted to add before we go? Okay, well, I want to thank you again so much for being here with us. We always look forward to partnering with you and Ada over at Raise the Floor to put on these Know Your Rights workshops. Once again, my name is Jannelle White. I'm with the Temp Worker Union Alliance Project, TWUAP. If you'd like more information about that, you can visit our website at TWUAP.org. We were also joined by Bobby Frierson, organizer at Warehouse Workers for Justice. If you'd like more information or to connect with him, you can visit their website at www.4j.org. And last but not least, our attorney, Mark Birhanu. I like to put the attorney there because I like to put some respect on it, but he's such a humble guy. If you'd like more information about Raise the Floor Alliance, you can connect with them via their website at raisetheflooralliance.org. So thank you to everyone who was able to join us today. Thank you to our viewers for submitting your questions and comments in the comment section over on Facebook. If you're catching the replay of this, feel free to leave comments. An organizer will get back to you as soon as possible. Also, please keep an eye out for our upcoming series in partnership with Temp Worker Justice. Unfortunately, Tyler couldn't stay with us the entire duration of this workshop, but he was on earlier. If you'd like more information about that, you can connect with Temp Worker Justice or TWUAP, and that will be launching next month in April of 2022. Thanks again, everyone. Be safe, be well, and we'll see you next time.
Thanks, everybody.